We have a big day today.
Grab a seat. Welcome all of you to the inaugural meeting of the Pretrial Justice Task Force. I'm really excited you all could be here. I'm so glad the weather held out for us. I wanted to make sure we met in December because I was worried if we waited till January we would have the weather to contend with, not realizing that December was going to be full of snow too. So thank you all for being here. I want to, before I make any further comments, I want to introduce Chief Justice Nuss, who is the reason you're all here. And because he stepped out of oral argument right now to come down and talk to you, so I want to be cognizant of his time commitment. So Chief Justice Nuss.
Thank you. Well, good morning.
Good morning.
Thank you all for coming for this important work. How do we know it's important? Well, if you look at the order that I signed creating the task force, among other things it says no person should be deprived of liberty unnecessarily or unconstitutionally. Now, how do we know it's important besides that statement? Well, Chief Judge Arnoldberger just said that at this time I should be on the bench presiding over oral arguments. The 7 justices are conducting court all this week. Attorneys are making their arguments on 4 cases on our docket. But when I talked with Chief Judge Arnoldberger earlier, she and I agreed this was taking priority. So I left Justice Lukert in charge. She's the Senior Associate Justice, and she's promised not to have an overthrow while I'm gone. Why else is this important that it would be proof of its importance? Well, so many people wanted to be members of this task force. And we decided that we would not appoint everybody who wanted to be a member because a task force can be unwieldy if it gets too large. We might have to rent Allen Fieldhouse at KU to hold a task force meeting if everybody who wanted to be on the task force had been granted that. So what we did, Judge Arnoldberger, Nancy Dixon, the judicial administrator, and I, we spent a lot of time looking over not only names of people who wanted to be appointed, but also people that we knew, if not by reputation, sometimes by direct experience with them. I'll pick on Sal for a minute. He and I were against each other years ago on a case, and I know what his practice is in Wichita, and I thought he would be a very good member. For the people who we could not choose, we still thought they had valuable perspectives, and we wanted their perspectives to be shared with you. And so we have appointed them as consultants or advisors, whatever term you want to use to describe them, and they are free to come to all the meetings. And when called upon by the chair or somebody else, they will tell you their thoughts, their experiences, what their research, if any, may show. We don't want to exclude different opinions on this. We also decided it would be very important to have as a member the person who had chaired a similar committee on municipal courts. That's Judge Brenda Stoss here at the front. So she was the chair of that committee over the last year, and she's going to bring her knowledge and experience from that committee to bear on what you're doing over the next 18 months. How else do we know it's important? Well, although this is a very short order, it took us a lot of time to draft it because we did not want you to have to fix the entire world, but we also wanted to make sure we knew what your mission was and what some of the specific objectives would be. I decided against bringing you my file folder on all the drafts that we went through on this, but this is probably draft 6 or 7. How else do we know it's important? Well, last Friday in this courtroom, I addressed the 31 chief judges from all across the state. They are the chief judges of our 31 judicial districts sitting in 105 counties. And I told those chief judges that as far as I was concerned, this task force ranked in the top 3 of the priorities that I see for the judicial branch for the next 18 months. That night when I was in Kansas City talking to leaders of the Kansas Bar Association, lawyers, and the leaders of the Kansas District Judges Association, district judges across the state, I told them the same thing. I regard this work as in the top 3 of our priorities for the next 18 months. Now, I do not know the magnitude or the scope of any problems we might have in Kansas on these issues, but we can't assume that since we haven't heard a lot about it, that there is not a problem. So looking into that is going to be one of your tasks. And another task is going to be, if you find problems, to recommend solutions to them. Solutions that maybe the Supreme Court can take, given our authority under Article 3, Section 1 of the Kansas Constitution, which makes us the general administrator of all courts in the state, or if it requires legislation. We could propose some legislation that we would send to friendly legislators who would be inclined to sponsor such bills with us. So, in closing, I very much look forward to receiving your report, and I thank you again for volunteering your time. Nobody thinks you're going to get paid for this, do you? This is your chance to leave if you were mistaken. One other thing I might mention, this was not something I was going to say because it might embarrass your chair, but I've known Chief Judge Arlberger since we were in law school together, and we appointed her the Chief Judge of the Kansas Court of Appeals several years ago because of her abilities in managing and supervising large projects. This is not the first time she's done something like this for the Supreme Court. We established a commission about 4 or 5 years ago about our budget, and she supervised start to say a motley group of people, but that would be unfair to you. Different backgrounds, and it took 6 or 8 months. This is a longer project, but she's very capable of being a leader. She always makes sure everybody's voices are heard, and I'm looking forward to receiving a tremendous report from all of you. And with your permission, I'll now get back to my day job, back to the Supreme Court courtroom. So thank you again for serving.
Thank you. So we have a heady task ahead of us, and what I want to correct, I don't ever get to correct Chief Justice Ness, but we didn't have 6 months with the budget project, we had 6 weeks, if you'll remember. It may have seemed like 6 months.
Well, so the timeline here, instead of 18 months, can you do it 18 weeks?
Oh, I don't think so.
If you're going to brag about yourself.
I know. But thank you all for coming. We do have a heady task and an important task for the next 18 months. And my role as chair is to make sure we get from day 1 to the last day when we submit our report in the most efficient way, taking in as many viewpoints as we can, making sure we've considered all angles to issues. You know, Lisa Taylor, the Public Information Officer for the state, and I have talked before because all over the country these issues are being discussed, and they're often referred to as pretrial justice reform. You need to know that we're even a step before pretrial justice reform. We don't know what, we haven't even defined whether and where reform is needed. So that's one of the things we're going to be looking at. And our goal in this group, as I see it, is to examine that delicate balance between the presumption of innocence that any person charged with a crime has and the interest of the public and the court system in risk of flight of that individual pretrial and risk to the public safety of that individual pretrial. So that's the balance we're going to be looking at, and how do judges make those decisions, and what can we do to help to make sure, as Chief Justice Ness said, that we are not unnecessarily incarcerating anybody pre-trial, because as we know, at that point they have not been convicted of any crime, and there are certain presumptions that go with that. So we have a lot of work to do, unfortunately, because we've got Professor Latessa is on a strict time schedule too. We don't have time to go around and introduce each other. We'll do that over the lunch hour. But because I want to be sure we get the full benefit of Professor Latessa's discussion with us today. You have his materials in your binder and his biography, so I won't go over that in a lot of detail. But Professor Latessa, I'm very happy you're here with us today. Welcome to Kansas, even though it's by video, and we look forward to hearing what you have to say.
Well, thank you. Thank you for that. And I do apologize for not being there in person. I did plan to come, but something's come up at the university that I absolutely could not get out of. So we thought this was the next best thing. And partly because you can turn me off if you find it too all right. I am on a fairly strict schedule. But hopefully, getting through the material won't take too long, and then we have plenty of time for questions. I have been doing workshops around the country on this topic. National Center for Courts has sponsored a number. I went to California and testified. They passed some legislation that some of you may know around this issue, and it is something that a lot of states are taking a very hard look at. So Kansas is not alone in looking at this issue. What I want to do is to kind of walk you through what I call a primer around pretrial assessment and try to then answer whatever questions you might have. So I'm going to go here and pull this up so we can get going. All right, can everybody see that?
Yes. Yes.
Okay, very good. It's a technology wonder. Yeah. And you can all hear me all right? Everybody can hear me okay?
Yes.
Yes.
Okay, very good. We have a lot of research over the years, and I've been to Kansas many times. In fact, we do a lot of work with the Kansas Department of Corrections around helping them with their correctional programs. And a big part of that is centers around risk assessment. And that research that's been done over the last 30 or so years has really identified a couple of principles, both that are somewhat relevant to pretrial. And those two principles are the risk principle and need principle. So we think about who do we want to target and what areas are driving that risk. So those are the two principles that a lot of this work is based on. If we look at the risk principle, the risk principle is really based on the risk of reoffending, not the seriousness of the offense. And so oftentimes we confuse the two. We look at serious, someone commits a serious felony, we consider them to be higher risk than someone who, say, commits a misdemeanor. But in this context, we're really talking about the probability that they'll continue to get into trouble again. It's certainly true in all the decision points of the criminal justice system that seriousness usually trumps risk. And what that means, of course, is that, if we take you as a group, you're all low risk. You're low risk because you don't have criminal histories, you're educated, you're employed, hopefully you're not substance abusers, you have family, so you don't have risk factors. But if you committed a serious crime, right, a serious felony, you could still be punished for that. You could still be incarcerated for that. Not because of your risk, but because of what you did. And this is certainly an important issue. It always is an important issue with pretrial as well. Basically, the risk principle says if we target higher risk people, we get stronger effects in terms of recidivism, and we can do some harm to lower risk offenders. And so this is what actuarial prediction looks like with a sample of, in this case, people that are supervised in the community. So in Kansas, for example, I believe you use the LSI, a level of service inventory. That's a widely used risk assessment instrument. It places people into categories. It's commonly used with probation and parole. The data you're looking at is based on a different assessment instrument, but very similar. And so if you look at this chart, what you see are 4 categories. The people assessed with this instrument have been placed into 4 buckets, if you will. Low risk, medium risk, high risk, and very high risk. Low risk, what this means is if you have 100 low risk individuals, less than 10% will recidivate. They'll end up back in for new behavior. Moderate risk, about 1/3. High risk, in this case, is about 60%. And this instrument gives you very high risk, which is about 70%. From a programming perspective, what it would mean is you'd have to put all 100 of the low-risk people in a program to get 10, because you don't know which ones are going to fail and which ones aren't. On the other hand, if you put 100 high-risk people in, you're putting 100 in to get 60 or 70. So just from a risk reduction perspective, we want to focus on higher risk people. But this is an important point, and it's true with any kind of risk assessment, whether it be pretrial or parole or probation. We are predicting to a group, not to an individual. An individual can score low risk and they can still fail. An individual can score high risk and still be successful. This is what actuarial prediction is all about. No one can predict for certainty what one individual is going to do in the future, but we can sort them out into groups pretty efficiently and effectively. The reason that we see harmful effects with low risk is we often put them in with high risk. We disrupt what makes them pro-social. And so again, you're an example. You're all low risk. If I took you and locked you up for 6 months, my guess is that you might lose your job. You might have, your families would have some challenges getting along without you. Most of your neighbors wouldn't have a welcome home from the correctional facility reception for you when you got out. So instead of reducing your risk, because you're all low risk, I'd actually give you some new risk factors. And increasing reporting and surveillance tends to lead to more violations and more revocations. And so these are the reasons we kind of see harm done when we target lower risk folks. It's a lot of data. This is a study from Canada, and you can see that when they put when they put high risk individuals into this intensive supervision program, their recidivism rate 2 years later was about 31%. The high risk that were not put in the program failed at 51%. So the program reduced recidivism quite a bit for high risk. The program increased recidivism for low risk. Low risk did as poorly as high risk, and not putting them under this form of supervision actually was much better. So, and I know you're thinking that's Canada, right? There's only 10 offenders in the whole country. So we look at some other data. This is a study we did in Ohio, where we had a big sample of 13,000 offenders. Half of them came out of prison, half of them were on probation. And when we looked at the data in Ohio, what we found was that putting low-risk individuals into these intensive programs actually led to increased recidivism rates for 3/4 of the program. So the red bars, what they're illustrating is how much worse those low-risk offenders did in those programs compared to low-risk offenders who weren't placed in those programs. The second chart shows you the same programs but the effects for high risk. And it's almost like I flipped the chart. What we see here is that most of the programs reduced recidivism for high risk, they increased recidivism for low risk. And where you see the risk principle, if you go out there to the second from the end, you see a program called in Mahoney County. That program reduced recidivism for high-risk offenders, right, 30-some%. But if we go back, we now see that same program is also second from the end, but in this case, it's second from the end on the red side. So it increased recidivism 29% for low risk. That helped tell us that it wasn't the program. The program was having an appreciable effect for high risk, increasing recidivism for low risk. Why is this important to pretrial? Well, there is some studies that show that when low-risk defendants are released to a condition that include alternatives, so they have to report often, they have to get go to a program, they may have to get drug tested all the time, they actually experience more pretrial failure. So in other words, the risk principle seems to work even with pretrial. These defendants were in effect over-supervised given their risk level. And so the risk principle is very strong. We see it in all kinds of correctional studies, and here we see it with pretrial as well. Because it's really telling us you're going to let low-risk folks out on OR or no bond. You don't want to put too many conditions on those low risk folks, because they will, just like, you know, like you're busy people. If I made you report all the time, you might miss an appointment, and then, you know, I've got to do something about it. So we see the risk principle. The need principle is really around the body of research related to risk factors. Right? So what's driving risk to reoffend? I think here we often have a narrow perspective. Folks tend to think, well, it's you know, substance abuse or it's mental health, when in fact that's a very narrow view of risk factors. So there's been a lot of research in this area. I'm not going to bore you with all the research, but it's basically led to what we consider to be a major set of risk factors. Antisocial attitudes, values and beliefs, cognitive emotional states. Cognitive emotional states are things like anger and rage and identity. So if you see yourself as a thug or a tough guy, that's your identity. If you think what you do is okay, you blame others, you minimize your behavior, right? You don't accept responsibility. Those are antisocial attitudes and values and beliefs. Second is pro-criminal associates, who you hang around with. And it's also isolation from anti-criminal others. So it's not just knowing criminals. Most of you know criminals because you're judging, right? But you have pro-social people in your life. You don't have antisocial attitudes, and you're not isolated from pro-social people. And so it's not just knowing criminals, but it's also this lack of pro-social people. Temperament and personality factors, things like socialization, acting impulsively without thinking, right? We see this a lot with offenders, right? You ask them why they did something and they have no answer for it, right? You say, well, you know, what happened? I don't know. What were you thinking? I don't know. I like to tell, I interviewed a parolee a while back, and I asked him if he was working. And he said, no, I quit my job. And I said, why? He said, well, I wasn't getting enough hours. I said, how many are you getting now? And he said, none. Right? And I said, well, you're moving backwards, right? Most of us won't quit a job till we have something else lined up. Not him. He showed them. So it's that impulsive behavior that often leads to trouble. Adventurous, restless aggressiveness, egocentrism, risk-taking, weak problem-solving skills. These are all kind of personality patterns that are conducive to criminal behavior. Now, again, just being egocentric doesn't make you criminal, right? I'd have to lock all the professors and judges up in this country, right? But if you're egocentric and you hang around with people that are antisocial and you use drugs and alcohol, you don't think anything you do is a problem, now your risk goes way up because you've got not only those criminal attributes, but you're also kind of insulated from any reflection or any insight. Fourth on the list, of course, is one you're all familiar with. It's the first thing you usually look at, and that's history of antisocial behavior. So how many times have you been arrested? You know, how old were you when you started? What kind of behavior, trouble did you have at school or other things? So those are what we call the big four. The fifth is family factors that include criminality. So your father's in prison, your uncles are in prison, that is a risk factor. But it's also a lack of cohesiveness, caring, affection in the family. For kids, it includes poor parental supervision and discipline, outright neglect and abuse. Sixth, low levels of personal, educational, vocational, or financial achievement. 7, low levels of involvement in pro-social leisure activities. And finally, substance abuse. So these are what we call the major set. There are minor risk factors. There are other risk factors that can increase or decrease risk, but they're not as strong. And these are obviously interrelated. It's important to remember people aren't usually high risk because they have a risk factor. They're high risk because they have a number of risk factors. Assessment, of course, tends to be the engine that drives effective correctional programs. We need it to meet the risk and need principle. One of the things we want to do is reduce bias. We want to make sure that people are treated similarly. And so risk assessment tools can help us do that. Now there's been some debate around this issue. There's those that argue that these tools are biased. The empirical evidence really doesn't support that. But I also want to point out that one of the advantages of using assessment tools is you have data. And you can ferret out bias if you want to. Because the alternative is intuition, judgment, seat in the pants. And so assessment tools, in my belief, can really help us reduce bias. Because we have data, we can look to make sure that different ethnic groups or racial groups or gender are performing at the same levels, and we're seeing similar failure rates and so on. And also, of course, one of the big reasons we do risk assessment is to help make decisions, right? In the case of pretrial, you're basically making a decision of, do I let this person out? What are the chances they'll show up again? What are the chances they'll get in trouble while they're out? And in probation and parole, we're making similar kind of decisions. We have known for a long time that the best method of assessment is actuarial, statistical versus clinical. And this next chart really just shows you a brief comparison of correlation between an actuarial statistical versus clinical assessment. It's really not even close. What this essentially means is if you took the best clinician, psychiatrist, or psychologist in Kansas, and you gave them 100 cases, and you gave me 100 cases, to predict recidivism, I'd beat them every time. Not because I'm smarter or better trained, but because I'm going to use an instrument that's going to pull a lot of relevant information together in a very statistical way versus my professional judgment. So there's really not a lot of debate among academics about the efficiency. To understand risk assessment, you really have to understand the types of risk factors. there's two basic types, and you saw them in that list. There's static factors that don't change, and these are things like criminal history. If you've been in jail 3 times before, you'll always have been in jail 3 times before. It can only go up. It can't go down. If your father was in prison, I can't change that. It's a predictor. Helps explain why you got in trouble, perhaps. But what am I going to do about it? Dynamic factors are things related to risk that can change. So if you don't have a job, you're currently using drugs, you're hanging around with people that get into trouble. We call those dynamic risk factors because they're related to risk, but they're changeable. They're also called criminogenic factors. But I want to point out there's 2 types of dynamic factors. There's things that can change quickly, and most of them are stable. An acute risk factor, for example, is employment. That can change quickly. Somebody can go out on a Friday and interview and start work on a Monday. Just like that, they went from unemployed to employed. Most risk factors, though, stable ones, or most dynamic ones, are stable. I'm not going to change how you think overnight. I'm not going to change who you hang around with. I'm not going to make you less impulsive. I'm not going to give you better coping skills. That isn't going to happen overnight. That's going to take time. And I like to use this as an example. These are the risk factors of having a heart attack. The first 3 are all important, but they're static. I can't change my family history. I can't change my gender. I can't change my age. But they're not the only risk factors. We've got other ones: inactive lifestyle, overweight, high blood pressure, smoking, high cholesterol. And if I have them all, and I want to reduce my risk, I've got to focus on what? The dynamic ones. I've got to lose weight. I've got to quit smoking. I've got to take some medicine to get my blood pressure down. Now, I can do all that and still have a heart attack, right? I mean, we see these people that jog all the time keel over heart attacks. That's why I don't exercise, right? But as a group, they would reduce their risk 20–30%. But I want to point out a couple of things. If you look at that list, there aren't many of those dynamic ones that are acute. Probably the only acute one may be smoking. That may be the only thing you can stop pretty quickly. It's hard, but people have done it. The other ones are going to take work. I also want to point something else out. Just because I can't change the static ones doesn't mean they're not important. Most of us aren't worried about having a heart attack when we're 20 years old. It's very rare. It's not until 50 that we start to see heart attacks increase. And so it's easy to say, well, let's worry about the dynamic ones, but the static ones are very important when we're trying to look at risk. We can't ignore them, and as you'll see in the pretrial tools, they really dominate a lot of those tools. These are some of the offender risk assessment tools that are commonly used in the field. The level of service inventory, which Kansas uses, the compass, which a number of states use, and the Ohio risk assessment system that is used in a number of states as well. This is an example of an LSI. So it's showing you this individual's risk factors and how they scored in each area. You can see they're high risk in criminal history, they're moderate high in education and employment, they're off the chart in companions, they're high in drug and alcohol, and so forth. This is a compass, this is what they produce, and the Ohio system is a little bit different because it contains a number of tools, including a pretrial assessment, a misdemeanor assessment, and some tools that are used in prisons. The Ohio tool, unlike the LSI, is non-proprietary, which means there's no cost associated with using this instrument. This is what the ORAS supervision tool produces. It's very simple to read. Judges can look at the speedometer and see where someone is, and then they can see the risk factors what's driving that risk underneath it. So that's kind of a 50-cent tour of risk assessment. So let's talk a little more about pretrial assessment. So we have a lot of studies, hundreds of studies around risk factors. Lots of consistency to what we call the basic domains. The domains are things like criminal history. That's a domain. There are a lot of indicators in it. Substance abuse, right? That's a domain. There are a lot of indicators. Well, what do you use? How often do you use it? How long have you been using it? Are you addicted? Are you just using socially, right? So think of a domain, and then within it there are indicators that help measure that domain. There are challenges though with pretrial, and they're fairly unique, and it's probably the reason there's a lot of consistency between the tools. These are some of the methodological and practical issues developed in pretrial assessment tools. First, you have all the problems associated with developing any tool. That includes the quality and the availability of data. You've got to have data in order to track outcomes, to see who fails and who succeeds. One of the challenges with pretrial is we often have a skewed sample. With probation or parole, I can look at everyone you put on probation. With parole, I can look at everyone that comes out of your prison. But with pretrial, I can only look at the people you let out. And we know that many times you're not letting out high risk or serious defendants. And so almost one of the problems is I'm by definition following or looking at a somewhat skewed sample. One of the other challenges with pretrial is we're looking at outcomes during the pretrial release period. That's a short follow-up. If I'm following someone on parole, they're going to be on parole for 2 years, 3 years, 4 years. I can follow them a long time to see who fails and succeeds. You let somebody out on pretrial, and they may only be out a couple of months before they have to come back to court. And so we have low failure rates. We call them low base rates, which makes it difficult to, it lessens our ability to predict. The other limitation of pretrial is these are defendants. They have not been convicted of a crime. There are things we should not be asking them. A good defense attorney would tell them what? Keep quiet. Don't tell them all these things. And so, unlike an LSI where someone's been convicted, there's a pretrial assessment, sitting down with that individual, you have all this information, you're asking them questions. With pretrial, you have a much more limited ability to collect information because of their status. Another constraint is time constraint. Because of the numbers, where you take, especially if you're looking in a bigger city like Topeka or others where there's a lot more cases, assessments you don't have an hour or two for each assessment. They tend to want to be done quicker, shorter. And then the final challenge is you're interested in two outcomes: failure to appear and to arrest. And you don't always have the same predictor for each of them. And so these are just some of the methodological and practical issues when we develop pretrial assessment tools. There are a number of tools out there, and most find similar predictors. These are the most common predictors. Prior failure to appear, right? That's a criminal history kind of a factor, and it's standard. Prior conviction, present charge, if it's a felony, being employed, history of drug use, and having a pending case. So these are common items. It doesn't mean that they're always on instruments, but if you look across the instruments, we see these. Some other common items: prior incarceration, community ties and residential stability, substance use, education, and age. These are, again, the most common factors we see on different tools. Let's look at a couple. This is the Ohio Pretrial Assessment Tool. It's short, it's not proprietary, there's minimal training. And so this instrument has 7 items. It can be done fairly quickly, training's minimal, and you score people low, medium, and high, and it places them into a group. Low risk, in this case, means they have less than a 5%, that group has a 5% probability of not showing up or getting in trouble again while they're under supervision, which is, you're not going to get much lower than that. Okay? Moderate risk, about 18%, and high risk, about 29%. Now, I do want to point out, if you compare this chart to the earlier chart, remember with the earlier chart, our moderate risk failed at 34%. Here, our high risk is failing at less than 30%. And so the reasons, again, because this short follow-up period, and you have some selection bias. You're only letting out certain people. This is what the distribution looks like typically. It's a pretty normal curve. About 28% of the people that were let out were low risk. Most fall into the moderate risk category, and about 19% or 20% were high risk. So it's usually a fairly normal distribution. It can vary by court, but we usually see more moderate risk in these groups. Another instrument that's getting a lot of attention, number of states are looking at it, is the Public Safety Assessment. This was developed by the Arnold Foundation. The Arnold Foundation's put a lot of money into criminal justice. Pretrial's been one of their large areas to study. They use data from Kentucky and other states to compare non-interview to interview-based assessments, and they found non-interview was just as predictive. Why is that important? Well, that means everything was scored from the computer. You didn't have to have a human sit down and interview someone. That means you can do it cheaper. Of course, that means you have to have good information in your system. Some judges, some courts like the interview process. They want to talk to that person and get information, but and you can do their instrument either way. But they wanted to demonstrate that you didn't have to have an interview. They looked at 3 outcomes: new criminal activity, failure to appear, and a new violent criminal activity. All right. They have 9 factors. They are all criminal history based. So there's no dynamic risk factors in this instrument. So these are the factors in the PSA. And all that stands for is new criminal activity. The second one is new violent criminal activity. And FTA is failure to appear. I will tell you as a caveat that predicting violence is very difficult. It's very hard. I'm always suspect when folks try to do it based on only a couple of items. So I've not seen the data from the Arnold tool. I've not seen how well it predicts. I know they're putting a lot of money into research and to implementation, but I'm always a little suspect when someone says we can predict violence with 3 or 4 variables. If we could do that, we'd have done it a long time ago. So I think you have to be very careful there with that. In terms of failure to appear and new criminal behavior, I'm sure it works just fine because it looks at things that most of the tools look at. So, a couple things about subjective versus objective pretrial. National Institute of Justice has found that when subjective processes versus objective is used, jail population increases. Most have found that use of a tool leads to more recommendations of release. And I think the reason's because the judges tend to have a little more information. It pulls information together. It's a little more scientific, and they have a little more confidence in it. So none of that surprises me that the tools tend to have an effect on jail populations. Some observations. If you're going to do just traditional pretrial programs, then, in other words, you just want to make a release decision. Do I hold them? Do I not hold them? Most tools are similar. Most are short and sweet, and most of them sort fairly well. If you use the PSA, if you use the Ohio, if you use the Virginia, they're all very similar. I don't think it makes that much difference. But some pretrial programs want to provide more services. Example are pretrial that divert people into drug court. So, for example, in Cincinnati, many years ago, we have a big pretrial program, and historically it was a very traditional pretrial program, right? In and out decisions. But then when the drug court started, they decided they were going to do pre-conviction or pre-adjudicated people would be eligible for the drug court. And so they decided they had to assess them in more detail. They wanted to know about their substance abuse and about some of the other risk factors. And so they decided for those individuals they were going to get their lawyers to agree to a more detailed assessment. They'd sign a release, and they would then use the ORAS. I think they started with the LSI. I think they use the ORAS now. So it really just depends on what you want to do. If you just want an in or out decision, the tools that are out there, if you're looking at diverting people into some treatment programs, then I think you need to consider a kind of a broader based tool. It takes more time, but you get a lot more information. Kind of a summary of research using quantitative or mixed quantitative and qualitative does tend to lower defendants' likelihood of pretrial misconduct. Your ability to impose sanctions and reports. If you have a pretrial unit, they can tell the court what's going on. You tend to see less pretrial misconduct. The more ways you can follow up on a failure to appear, the less pretrial misconduct. And there's some evidence, but as you'll see, it's mixed, that providing reminders can reduce failure to appear rates. There have been a few studies on electronic monitoring, but there's no conclusive evidence that it's necessarily effective in reducing failures to appear or new arrests. As you know, electronic monitoring doesn't stop somebody from doing something. They can cut the cord, they can leave, they can commit crimes at home, and so there's not a lot of evidence. Some judges feel more comfortable putting people on electronic monitoring, now GPS monitoring for domestic violence offenders and so forth. But in terms of the research, we're not clear it makes much difference. Substance abuse testing is another thing that is common. There doesn't seem to be any difference with higher risk, but lower risk appear to do better. My guess is because the lower risk people are just socially using. And so if you drug test them, they'll quit. Higher risk, they have more serious problems, and drug tests aren't necessarily going to help them or have them refrain from using drugs. Targeting mental health screening does tend to lower the likelihood of pretrial misconduct, but requiring treatment does not appear to make much difference. So if you're going to take somebody mentally ill, get them out of your jail, make them go to treatment, it may not make much difference. But again, there's not a lot of research here on some of these things. Again, Arnold is spending some money to study them. We'll probably know more in a few years, but this is the research we have available. Let's talk a little bit about failure to appear rates. They vary tremendously. There's no acceptable rate, right? That really depends on the jurisdiction. We see as low as 5, as high as 25%. We see differences in geography, political, court capacity, and whether or not a court uses different notification methods. In some ways, your FTA rate's going to be decided by what you can accept. Historically, notification were phone calls or postcards. Most of those early studies showed it reduced failure to appears, anywhere from 4% to 25%. Most of this focused on notification, not when do you do it. Here's some studies. Nebraska, which is a state, close to you, looked at 4 different kind of conditions, right? Basic reminder, a reminder with sanctions, a reminder with sanctions and benefits, and no reminder. They found the reminder with sanctions had the lowest rate, but they're low to begin with, 8% versus 12%. In other words, if the reminder said, you have a court date on this date in courtroom A, and if you don't show up, we're going to issue a warrant for your arrest, that had the best effect. They also looked at race and ethnicity, sex, geographic, offense type, and number of charges. The rates varied by race, but after controlling for offense and number of charges, there were no significant difference. They did vary by number of offenses. So people that had more serious charges, those with multiple charges, higher failure rates. But let me say this, that's going to be captured in an assessment tool. Those are things that are often in assessment tools. Did not vary by race, by sex, but it did vary by locations. Urban counties had higher failure to appear rates, rural counties had somewhat lower failure to appear rates. They also found that institutional competence made a difference. If the folks believed they would be treated fairly, they had lower failure rates. And of course, this is often driven by racial differences. So whites had more dispositional trust than non-whites. And so that may explain the urban-rural difference a little more as well. But a reminder was more effective for those that had relatively low trust. So using that reminder helped reduce that rate a little bit. Historically, it was phone calls, postcards. Now we've moved to text messages, and it's very clear they are more effective than email. Email has what we call a very high, doesn't have a high open rate. And we all know this, we get emails all day and we can tell that they're not relevant, or they've gone out to everybody and we just hit delete, delete, delete. Text, people tend to respond to. And so if you're going to do a notification system, my advice is you do text. We all get them from our doctors, right? You have an appointment. If you're not going to come, hit no or whatever. And so that's what technology is able to do now. There are no studies in corrections on timing, but there are some studies from the health field. One study found a text message within 3 days reduced missed appointments. Others dropped by 13% if they were texted within 24 hours. So timing of the text closer to the event tends to make a difference. And failure to appears, you want to have a low rate because they're very expensive. The judge, the lawyers, everybody's sitting around, and you have to issue a warrant. They often get arrested, and so getting that rate low is very important. Now, a recent study by Lowenkamp and Holsinger Alex is at UMKC, so he's a former student of mine. He's a great resource. I know he's done work in Kansas. They looked at a lot of cases in 10,000 cases in Kentucky. They had 5 groups: call with warning, nothing, text, and text warning. They found it did not make a difference. The rates were low for every group. But again, they were very low. And so, and I just read a study out of, I think, Sweden. They found that, again, rates were low and it didn't really make any difference. So, again, the research is a little mixed, but if you look at the preponderance of studies, it would probably err toward some kind of reminder. Plus, if you give them a reminder and they don't show up, you've kind of taken away that excuse that nobody told you about it. These are some challenges: time constraints and the practicality of the assessment. Can I improve your assessment? Yes, but it's going to take a lot longer to do. And so pretrial tends to want it short and sweet, quick, and so there's a practical consideration. Money bail schedules and the bail industry. That is a very powerful lobby. Don't underestimate their ability to fight against this. California passed legislation, and I've been talking to the folks out there. The bail industry decided that they could not fight it in the legislature, but they're going to fight it in. They're collecting ballots to put it as a referendum, and so they decided to spend their money. California is a referendum state. They've decided to spend their money to get it on the ballot. I talked to the chief judge in Maryland a few weeks ago. They tried to craft some legislation, and the bail industry basically got it deep six. So that's always an issue. You have local capacity issues. Do you have a pretrial officers? Who's going to do it? Can you validate it? These are things you should, you think about. Again, subjective assessments. And court culture and judicial behavior. I don't think that the prediction for pretrial release is going to get that much better for all the reasons I gave. I think the instruments that are out there, they work pretty well. At the end of the day, the judges have to make a decision. And I understand that. You don't want to see your name in the paper if you let somebody out and they committed a serious crime. So those are challenges, and it's everybody faces them, and you'll kind of be no different. These are some of the kind of implementation. What do you want to use it for? You just want to use it for an in or out decision. You want to use it to put somebody in a program. How long does it take? How much training? What's it cost? How complex is it? When will it be done? Where will it be done? Who's going to do it? The staff support it? And is it reliable and is it valid? And let me talk just a minute about those two concepts. Validation and validating an instrument means it's measuring what you think it's measuring. Reliability, is it being done well? Right? We typically look at inter-rater reliability. So if I score a defendant, you score a defendant, somebody else scores a defendant, we want to make sure we're coming to the same conclusion. We could all be wrong. Coming to the same conclusions, reliability. Being wrong is validity. Two things tend to affect reliability: training and experience. Like anything else, the more you do, the better you get at it. And folks need to be trained on whatever instrument you decide to use. As I said when I started, pretrial is hotly contested right now. Some of the research is inconsistent and contradictory. There are challenges that limit our academic and methodological rigor, such as random assignment. Validated tools can help courts make decisions, but they're not foolproof. Nothing's foolproof. You can reduce your risk of being wrong by taking less chances, but then you're letting less defendants out. These tools, place them into categories, but seriousness of the current charge is a commonly used factor that the court takes into account. If you look at the California legislation, they require an assessment tool, but they exempt a number of offenses, and so you can all imagine what they are. They tend to be the violent offenses, and so they get exempted. Seriousness usually trumps risk when it comes to this process. We don't, until we have more studies, effects about the kind of the effects of pretrial are speculative, right? And so probably the best, most recent, what we call meta-analysis was done by, again, Lowenkamp and some of my colleagues. They found 800 manuscripts, but when they sifted through them, only 16 studies had methodological rigor. And they concluded that the quality of the research was not very good, with a few exceptions. They also noted that while you have to look at it with caution, it did appear that more restrictive bonds were associated with lower failure to appear rates. But there were only 2 studies that looked at cash bonds and whether they had any effect. They did feel more confident in finding that court notification reduced failure rates. So they did feel that that research probably enough to warrant notifying people to reduce it. So just in ending, couple summary points. There's no one size fits all. If you want, some types of offenders, we do additional assessment. Sex offender, domestic violence, there are some tools out there. Just depends on what you want, what do you want to do. Actuarial is more accurate than clinical, but nothing's perfect. We can get about, with pretrial tools, probably 75% accuracy, but they're always, again, going to be false positives and false negatives. People we think are going to fail that don't, and people that we don't think that are going to fail that will. Assessment guides that helps guide decision. It does not make it. Professional discretion is still part of an assessment process. In other words, you get all the information, you look at the case, and you still decide based on your experience, what should you do? I never advocate that anybody blindly follows some tool, and certainly not true with pretrial. Reliability is a little more difficult with dynamic instruments. It requires more training than static, but static instruments are limited in what they look at. They tend to look at historical factors. The one thing you should know in terms of bias, in the good empirical studies of bias, and mainly here racial bias, the one area where there does seem to be bias is criminal history, not in the other areas. And the reason is because African Americans, Hispanics tend to get stopped by the police more, they're in their neighborhoods more, and so that is one area of concern when you look at criminal history. Again, some items aren't as big a deal, but number of arrests, for example, that can affect that. And so there is a lot of interest in looking at bias right now. And I know Arnold's going to study that in more detail, but that is something that folks are concerned about. So that's kind of the thumbnail sketch of what we know, and I'm happy to answer any questions you have.
We thank you very much. We do have quite a bit of time, or several minutes of Professor Latessa's time left. First, is anybody on the task force? And I know we've just jumped in our first meeting with some pretty detailed discussions. Does anybody on the task force have questions they'd like to ask the professor? No task force members? How about any of our interested advisors that are here that would be interested in asking any questions of Professor Latessa? And am I pronouncing that right?
Yeah, it's free now, so I am.
Yep. You've got the expert here to ask.
Actually, I have a question, Professor.
Yeah.
Each of these risk assessment tools, maybe I just missed it. How long does each one of these take to go through each one of these? Like, for example, the LSI, the Compass, and the higher risk.
Yeah, they're done a little different. The LSI is probably on average 45 minutes to an hour. The Compass is a machine-scored instrument, so you collect a lot of information and you put it in the computer and it spits out a risk assessment. I'm not a big fan of machine-scored, and I'll tell you why. They're not transparent. You don't know what and why it scored what you did. With the LSI, for example, the assessor that makes the assessment decision and scores it. So I like instruments that have some human element to them. But they usually take about an hour. The pretrial assessment tools usually take about 15 minutes, depending on whether you have the file and the criminal history data and so forth available to you. They're much shorter.
Can I ask a follow-up on that?
Oh, please.
Can you talk about whether there's any analysis or study of who it is conducting, who the assessor is that's conducting or implementing the tool and scoring it, and whether that has implications? So for example, if it's a law enforcement officer that's the assessor, or if it's an officer of the court that's the assessor, or if it's the prosecution or the prosecutor's office that's doing it, how does that influence the statistics?
I don't know of anyone that has looked specifically at that, in part because it would be very rare for law enforcement to complete the assessment and or the prosecutor. Typically, these assessments are done either by probation, if pretrial is housed in probation, and it is often in a number of jurisdictions, or a separate pretrial unit. So in other words, there's someone specifically hired to do the assessments and then to give the court information and to follow up. So in bigger jurisdictions, they tend to have a pretrial unit. What we look at typically when we study it is is it reliable? Are they doing it accurately? And the way we do that is we give them all similar cases. We make sure they're scoring it correctly. They're coming to the same conclusions. It's not a major, as big an issue with pretrial because of the nature of the instrument. Right? It's not a long, involved instrument. They tend to be a little shorter, mostly static factors. But you still want to make sure they're doing it well. I've never seen, the only instrument I've ever seen that could be done by law enforcement is there's an instrument called the ODERA, the Ontario Domestic Violence Risk Appraisal, which is used often by law enforcement when they go out on a domestic violence call. But that's the only, I've never seen any pretrial tool be used in a law enforcement setting.
What about the...
Typically, prosecutor's office could be doing it, but again, I have never seen a study that looks at did that make a difference.
What about the computer-scored assessments? Is the information that's being used or being inputted into a computer-scored assessment, is that information being gathered by the law enforcement at booking, or is that information being gathered by somebody who meets with them or whatever?
Well, it depends. Like the Arnold tool, if you want to use the Arnold tool automated, they would come in to make sure you had in your computer system the information they need to score it. And they don't it wouldn't, to them, they don't care where it came from. In other words, it can come from the court, it can come from probation, it could come from the DOC, or it could be part of your law enforcement records. That, you know, in Ohio we have what we call OLAC. So law enforcement puts in arrests and stops and so forth. But courts then have information related to prior failure to appear. That might not be in OLAC. So if Ohio wanted to be fully automated, they'd have to go to different systems. I don't know enough about how or where you keep your data. With the human piece, let's say I'm a probation or a pretrial officer, what I would do is I would print your record, whatever source of information, source keeps your information, I'd print that, and then I'd score based on that information that I have. So you have 5 prior arrests, you've been incarcerated 6 times, you've had 3 failure to appears. I don't need to ask you that, assuming that I have accurate information. I might have to ask you to verify your employment or verify your residence if that's in the tool, because I want to know where you live and how long have you lived there. Because if you're, you know, if you lived and owned a house in Topeka for 20 years, you're probably not going to skip town. Okay? But that doesn't predict rearrest. That predicts period to appear. So the information, it just depends on which tool and what information is included.
I'm wondering practically how this would work and what jurisdictions do that use the assessment. You've got probable cause affidavit, and the judge looks at that and sets a bond, you know, within 24 hours of arrest. Is
Right.
there any way that an assessment's done before the judge makes that initial probable cause determination and a bond? Or?
Yeah, it depends on the jurisdiction, but in Cincinnati, for example, if you're arrested, assuming that you're not incapacitated, they do 24-hour assessment. They do it right into jail, right after booking, and that judge gets that information first thing in the morning.
And so they've got somebody who is, that's their job, they do.
That's their job. That's their job. They sit in courtroom A next to the judge and they give them the information.
And how do you verify that? I mean, if I'm sitting in jail and I want to get out, I say, no, I've never been arrested. No, I don't have
No,
drug problem.
they have access to the court. They have access to the criminal history data through the computer, through their leads or their NCIS or whatever system the state uses. So no, they don't. Now, some of them lie. I don't know if you knew that, Judge, but some of them lie. Yeah, no, that information, criminal history data is usually verified data. They may not, you know, some things like employment may be a little tougher if it's at midnight. But generally, it just depends on what the instrument is and what data they have available to. Usually, it would be verified, or they would tell the court, we couldn't score it. We don't know. We can't verify this information. Right? In which case, the court would have to decide what are they going to do.
So for example, if they tell you verbally, I've never failed to appear in court before, and you don't really have a way to check whether, I mean, you may be able to see if they've had any warrants for failure to appear, but that may be the only thing you'd be able to determine statewide. Would that be something that you just don't score, or?
You could not score it. I mean, we train them and say if it's not available, if the item you don't know, we don't want you guessing, right? So it would not be scored. But most courts have a court management system that can tell you that. The rare would be if it was another state, they came from another state, you didn't have access. But then, what do you do now? I mean, you make some kind of decision, you know, about it. So I think, you know, one argument I heard, and it's a good one. When you set a cash bail, even for a serious case, if they have the money, you let them out. I mean, hey, you post a $50,000 bond, you let them out. I mean, that may reduce their failure to appear rate because they don't want to lose the 50 grand, but they can still go out and intimidate witnesses and do all kinds of things. So you know, it's really about are there people that are being held in jail simply because they can't afford it, that we could take a good risk on, and they're probably going to show up, they're probably not going to get in trouble again in the next 3 months, and let's get them out. But we don't know very well. There have been some studies, but we don't know at what point is harm done. In other words, I keep you in jail Saturday and Sunday, maybe no harm is done. But I keep you 2 weeks, now maybe you lost your job. Right? And so that research really hasn't been done very well yet. We suspect that there is some harm for some people, but again, I can't say what that time period is.
On page 16, you have that little 7-paragraph pretrial assessment tool. Is that what you would recommend using?
Well, no, that's the Ohio tool. The 3 major tools that are kind of, well, there are lots of tools. Some people build their own tools. The Ohio tool is used, the Virginia tool is used, and now the PSA's tool is used. They're all very similar. They're all, I think Virginia's free, Ohio's free, Arnold's free. Arnold will come in and work with you as well to set it up. Our tool we give to you is minimal training. But any tool you pick, you're going to want to validate it. You know, as part of your commission's recommendations, you know, if you decide, yes, we recommend the tool, if you look at California's legislation, they're very clear. They said, we want jurisdictions to use a tool, but we want to make sure they validate the tool. We want to make sure it's working the way it's supposed to work. And so I think it's less important which tool than making sure that the tool is actually being done well and giving you information that puts people into those categories you're comfortable with.
You mentioned that one area on the tool that we should be concerned with was criminal history as it pertains to bias. Are there other areas in these tools we should take a close look at with regard to bias?
If you look at, you know, there was published a major study that, again, one of my former students, Lowenkamp, and someone else did, looking at all the areas, substance abuse, family, peers, critical thinking. There was the only area where there was bias, some bias, not a lot of bias, was criminal history. And how we look at bias with instruments is we're looking to see that different groups are failing at the same rates within categories. Right? So in other words, a group of high-risk African Americans are failing at 50%, and a group of high-risk Caucasians are failing at 48%. We would say there's very little bias there. On the other hand, African Americans are failing at much higher rates than the whites. We'd say, we have a problem. We have to look at it. The one area where we do see some differences often is males and females. And so, again, we don't want to overclassify women. We don't want to put them in a category, you know, say they're high risk when they're only failing at 20% rates versus the men who are failing at, say, 40% rate. And there's different ways that's done. One is you adjust the cutoff scores. So women then can have more points to be in the same category. So these are things researchers look at to make sure there isn't bias in it, because you want to eliminate that.
Has there been any work done on failure rates based on whether or not there are costs associated with these pretrial supervision programs? For example, a person may be sitting in jail because they can't post the $10,000 bond, but they're released, but then have electronic monitoring fees or probation fees, and that may cause a failure, just the fee itself. Has there been any?
Well, again, there've been some, not necessarily a pretrial, some cost studies. You know, I'm a little skeptical because, yes, we know how much it costs to keep somebody in jail, but, you know, letting somebody out, I don't know if you're saving that much money, right? Because, you know, there's an economy of scale cost there. And you're right, if we're now going to put them on electronic monitoring, make them pay for that, make them pay for the drug test, and so forth, some of them are going to say, keep me in jail, right? Because I don't have the money for that. I think if you're going to create a pre-trial service, you're going to require electronic monitoring for some people. You're going to require drug testing. I would be very selective with that. Right? I would never use that for low-risk people. You're just going to increase your failure rates. Right? That would be restricted to a very small group of people that, you know, I mean, the same thing you might do with a cash bail. You might say, I'm going to give you a bail, but you still have to be under electronic monitoring. So I would be very selective. Because you're just moving the cost from one area to another.
Right.
Yeah.
Any other questions?
I got one.
Just a second.
On that Ohio deal, you know, what's the defense bar attitude where you've got a guy arrested for possession of meth, and number 5 is any illegal drug use in the last 6 months?
Or self-reported drug.
Well, they get a point. It doesn't mean they're high risk. It just means they get a point for that. And
Yeah,
so
but I mean,
the
they
more
don't wanna
points
answer
they
that.
get, the higher the risk. Yeah.
I guess the point is they won't answer. I mean, they'll be
Well,
advised
they don't have to answer. We know if they've been arrested or not. We know what they've been arrested for. They print that right out of the computer. They don't ask them that. They don't need to ask them that.
Well, but how about
With regard to arrest, they know what the charge was. They know what the disposition was. They know what, you know, if they were convicted.
Okay, but how about the next one that says defendant self-reported severe drug-related problems? And it looks like you get a point if they do self-report, which seems a little bit counterintuitive to me. What's the experience with something like that?
Hold on.
It's question number 6 there.
Yeah, I see it. What's there? I'd have to look at the scoring guide to see how they define that. I know what that is, and that's like the 1 to 3 and the 4 to 5. They basically are asked, you know, on a scale, you know, how hard would you say your drug problem is, and then they circle that they self-report it. So if they deny it, they get no points. If they say yes, they do. But you also have above it legal drug use. So if they have a conviction for drug use and they deny it, you know, then you're finding out, you know, basically when you're lying to me because you've been, you know, you've been convicted of it here in the last 6 months. But I have to see the scale on that and how they score.
Any other task force members have a question? And I'll ask you again. Senator Haley, you had a question.
Just briefly, yet in its infancy, are there any pros and cons, takeaways from California and the model that it gave that the task force could look at for recommendations, things we've learned practically from the legislation? Yeah. Though it's still early, some things to avoid, some things to employ.
And that, yeah, I might remind the people here, the California system basically eliminated the monetary bond system.
Yeah, for some, yeah. California, I can tell you a little bit about the process, and the process is very similar to what you're doing in Kansas. The Supreme Court justice appointed a task force. They met. They had, I went out there, others went out there. talked to them about what the issues were. They were able to craft and pass legislation, basically misdemeanors, eliminated cash bond for misdemeanors, with some notable exceptions. They require a risk assessment tool with, if you score low, you should be let out, unless it's certain violent offenses and so forth. So that's how they crafted it. They were able to get it passed, but as I said, it's now being held up because I believe there's enough signatures to put it on the ballot for a vote in the next election. So the pre-trial industry decided they weren't going to fight it in the legislature. They were going to fight it with, and they'll run a lot of ads and say, we're going to let everybody out of jail and so forth. And I don't know who's advocating on the other side. So my guess is more money will go into fighting this legislation. So I do know California has an administrative office of the courts that oversees it. The legislation requires some experts be appointed to kind of review the instruments to make sure that whatever they're using is valid. I've had some calls with them about that process, but right now I think everything's on hold in California because of this issue. Probably the state that has the most experience with pretrial is Kentucky. Kentucky's had a model pretrial program in every county for many, many, many years. And so Kentucky is the one state that I think has probably the most experience over the longest period of time. Now, I've heard that they tested the Arnold instrument and then they left the Arnold instrument. They went back to something they were using before. But, I don't talk to these folks all the time, so I don't know for sure. But I would talk to probably the Kentucky court folks and then the California to get more information. I try to stay out of the weeds with this stuff because I don't really like politicians.
Other questions from the group? Anybody?
Sure, I have one.
Sure, go ahead.
It's my understanding that New Jersey, they've adopted didn't have a cash bail system for like the last 2 years, and I believe the SMU School of Law kind of did a research study recently to see if they had been effective. And I'm just curious if you had a chance to take a look at this study, or if you have any other comments about New Jersey's system of eliminating.
Yeah, I only know a little bit about Jersey's system. I did read something. I haven't read the SMU, but I did read something that basically New Jersey said it's too early to know how much effect it's had. And I just read that within the last week. I don't remember exactly where. But again, New Jersey's a state you might want to talk to as well. Of course, it's very different than Kansas. It's a very urban state. So it is different. You probably look more like, in Ohio or states with, more rural areas. But Jersey is another state that has moved in this direction. And again, there's a lot of states taking a look at this issue.
Yes.
Professor, in the standardized tools that you have looked at, Kansas has previously used victim feedback in assessing in domestic violence cases, setting bonds, and the risk that might be there in setting those bonds. Have you looked at any of the standardized pretrial ones that actually give victim input into the assessments?
No, I've not seen it in any assessments. And again, part of it's the timing, right? So if I'm going to assess you at 2 in the morning when you're sitting in jail and come to the court in the morning, I don't have time for that. I don't know if anybody that's very common in pretrial, in pre-sentence assessments or reports, right? You want a victim impact statement and so forth. I've never seen any in pretrial. That's very interesting addition to it. Maybe I'll do it on my next
Your next young graduate student will get that assignment.
Yeah. And let me say this too, even about the Ohio tool. We collect a lot of data with regard to the community supervision tool, the prison tools. We don't really do a lot with the pretrial tool. We don't even know who all uses it. Anybody that wants to use it, we give it to them. We'll do a video training with them. So it's not something we've really paid a lot of attention to. We are doing a new study in Ohio, and I think there's been about 30,000 assessments done with the pretrial tool. So we'll look at that data. But it's really not been high, something we've really kept track of like we do the other instruments.
Other questions before we say goodbye? Did you have one, Mr. Williams?
Yes, Professor, as we look at Kentucky, are there any studies, any papers that have been written, anybody looked into Kentucky since they seem to have the longest history? Any places we can go for source?
A lot of the Arnold research, it started in Kentucky because they had the most data and they've done it the longest. So there's a number of empirical studies that have used Kentucky for the pretrial.
Well,
they have the best data.
The reason I ask is, in my looking, the only thing I ran across that popped up quickly was the article by Professor Stevenson. Have you seen that?
No, I probably have.
Megan Stevenson. Yeah. It came out in June of this year.
Are you looking? Is it a law journal or is it an academic?
It's
more, empirical.
I'm not sure, to be honest with you.
Yeah.
But it's about a 65-page article, and has, like you did, it has the graphs and the charts and all of that stuff. I just wondered.
I'll tell you what, when we get off the phone, I will send pretty detailed bibliography of the pretrial research, especially some of the stuff that's been done in the last few years. And you should be able to find most of it either online or in some of the academic journals. So, and there's been a number of, Arnold's just been cranking out a number of studies. So I'm happy to send you that. And I was an expert witness down in Florida on a case, so I had to go through all that research. So I'll get that to you.
Thank you, sir.
Okay, I think we're about...
Whoever wanted to know about pretrial.
I think Professor Latessa said he needed to get away from us at 11:30, so if there are no other questions, thank you very, very much for your presentation. We appreciate it greatly as we begin this journey.
All right, good luck. And if you need anything, just let me know.
Okay, thank you.
All right.
Bye.
Bye-bye.
Do we have 11:30, where's John? Do we have 11:30 set as lunch?
11:45.
Oh, 11:45, okay. Again, I apologize that we had to kind of jump into the heart of the issue from the very beginning, but when we initially planned this day, we had the order a little different so that it would make a little more sense maybe to get to Professor Latessa's comments maybe at the end of the day after we'd seen some of the legal issues and the legislative issues. But because of his schedule, we had to put him first. So we have, as a task force, dived into the heart of the issue. And I also don't want you to think that just because we had the risk assessment session first means that somehow we are predetermined to go down the risk assessment path. There are no predeterminations of this task force. We're going to be looking at each issue, the pros and cons of each issue. I'm sure we'll be looking at Kentucky studies if those are available. And whatever the California experience to see what's happening there and what's anticipated to happen there. I think what we're going to do at this point is give you a break, and then a short break, and then at 11:45, the task force is going to meet for lunch.
The OJA conference room. The
OJA conference room, which we can lead you to where that is. So that we can all just get a chance to meet each other and say hello, and before we get into more educational sessions this afternoon. So with that, we'll take a break, give you a chance to take care of business, and see you in the OJA conference room at 11:45.
And we'll start back up here at 1.
We'll start back in this room at 1 o'clock.